Justice denied to a 14-year-old girl. That's what happened when a Bengaluru court acquitted a plumber who had been accused of raping the girl in 2012 when she was just 7 years old. It's a case of shoddy investigation by the police who failed to produce conclusive evidence in front of the court. In fact, the court observed in the judgment that the prosecution had miserably failed to prove the case. Now, according to the FIR, in July 2012, the 7-year-old girl was allegedly raped in the bathroom of a prominent school by a plumber. Now, the prosecution also alleged in court that school authorities took the matter lightly when they complained and asked the child to forgive and forget. However, defense lawyers in court said that the accused was not present in school premises on the days mentioned in the FIR. In fact, they argued further that the girl weaved fanciful stories and that the school principal had claimed that the girl had a vivid imagination. Now, defense lawyers also claimed that the girl had failed to identify the accused when there was an identification parade in the principal's office. In the meantime, what's most concerning is that the court observed how the prosecution, the police, had miserably failed in their job. Now, the court listed how the police did not speak to the first doctor who had examined the girl and had even failed to produce the forensic test report in front of the court. Now, the court also pointed out how the police did not find out where and who the accomplices were actually. In fact, one of the city's top-notch lawyers, C.H. Hanumantraya, represented the accused in the court. He backed the principal's claims that the child had fanciful imagination.
So you did, of course, mention saying that the child was weaving fanciful stories. You did say it's mentioned in the judgment clearly. Now, do you think a mother will be capable of, tutoring her child to tell she was raped?
But the child could overcome that. That was in the nature of the child. It's a weaving of stories, coming out with exaggerated version and all those. That was akin to the nature of the child. Tutoring of the mother could not suppress it, could not make the child, get out of that. The inherent qualities of the child could overcome even the tutoring of the mother.
Right.
She would, in her cross-examination, when I was going on with the cross-examination, she would become forgetful of what her mother had told her to say in the court. And she would spontaneously, sometimes, not every time, she would spontaneously respond to my question.
In fact, even the assistant prosecutor, B.T. Venkatesh, admitted that there were serious lapses in the investigation and that they fell short in court because of that.
It's not the question of, say, falling flat. The question is that the quality of investigation being poor is one of the biggest challenges that we have in this country. That the nature of investigation that takes place and the kind of evidences that are collected, details of the evidence that are collected in these cases, being in a way which is not appropriate, results in opportunity for the defense to raise serious doubts into the story of the prosecution.
Now, the acquittal and the manner in which the prosecution handled the case has drawn strong reactions from women activists in Bengaluru.
Here is a case where the victim has been, I somehow feel, has been the victim of circumstances. Even in the court, the prosecutor was duty-bound to place the medical records. I do not know why he has not placed the records, why the FSL records were not placed before the court. What was the justification? In the event of not being produced, what was the judge doing? He should have called upon the FSL people or the medical people to produce the records. He is there only to give justice, not to hear what these people say.